Good morning, everyone. Good morning to all the teams. Today we have along with us Advocate Dharmesh Mehta, sir. He's been a consultant advocate. He's been a lecturer for the past 8 years in all law colleges. And he's also been the IC principal for 3 years from Sri L.R. Tiwari Law College. We welcome you. We give a very warm welcome to you, sir. I request our IC principal, ma'am, Dr. Mrs. Madhura Karamkar, ma'am, to felicitate, sir. I request Dharmesh sir to please speak a few words from the plethora of knowledge that he pursues throughout years.
All the mooters, you should be not afraid of anything. It is just a training. All the mooters, you should not be afraid about anything. You know about the law, you know about the procedure. So this is only a practice where it will lead you to the future of litigation. So all of you should go with the legal spirit, and you should speak out, because our profession is to speak. And freedom of speech, you know, it is all reasonable restriction is always being there. So speak with all the evidence, all the things, materials, and be successful in your career also, because very soon you will be in the live court. So this is just a pre-trial for you. So all of you should work hard. All the best. Thank you.
Thank you so much, sir, for motivating our participants. And without any further prolonging, we'll start with our event. We have VTM 05 versus VTM 02 to go first. So I request VTM 03 and 4 to kindly leave the meeting. You will be intimated as soon as they are done. VTM 04 versus VTM 02. 5 versus 2. I request the VTM 04 researcher to kindly leave the meeting, please. Yeah. VTM 05 versus VTM 02. Speaker. VTM 02. Speaker 1 and speaker 2. Okay, so the prosecution goes first. All the best. Go ahead.
May it please the Honorable Court, I am the prosecutor appearing on behalf of state. May it please the Honorable Court, may the prosecution proceed with the statement of jurisdiction. Hello?
Please proceed. Yeah, please proceed.
Hello, sir.
Yeah, you may proceed.
Okay, much obliged, sir. That this present case is filed in lieu of offence committed under section 300, 302, 324, 34 and 201 of the IPC 1860. that the offense committed by the accused is classified as cognizable and non-bailable, that the offense committed under section 300 is punishable with death, imprisonment for life, and also liable to fine under section 302, that the offense committed by the accused under section 302 under section 26 reference with first schedule of the Code of Criminal Procedure 1937 is triable by the Court of Session. Hence, this honorable court has complete jurisdiction over the present case, to which the petitioner humbly submits.
You may proceed.
Okay. May I please the honorable court, like if the court is well versed with the facts of the case, then prosecutor would like to proceed with the issues and arguments.
Yeah, please proceed. Please proceed.
Okay, sure, sir. Much obliged, sir.
Yeah.
May I please the honorable court, the prosecution seeks your pardon for typographical error in the statement of issues and humbly requests to be allowed to amend the same.
Where it is?
Sir, it is in the statement of issues.
Hmm. Okay. Okay, you can edit the post.
Much obliged, Honor.
That provision lies under which section? Amendment of. Please mention the provision of an amendment which you wish to bring before the court.
So the issues which has been specified in the memorial and the issues which are raised in the arguments, there's difference in that, because the issues which are raised in the argument same needs to be reflected in the statement of issue.
Okay,
so the amendment
what
needs
is
to
the
be done.
provision? I say, what is the legal provision for amendment? State
Sir,
the legal provision.
we can amend it to the in the next hearing.
Okay, please proceed. Please proceed.
Yeah, much obliged, sir. Whether the prosecution has been able to prove the guilt of the accused beyond the reasonable doubt. That's a first issue.
Okay.
On that, our explanation is yes, the accused number 1 and accused number 2. Accused number 1 being Surekha Singh and accused number 2 being Mohan Prakash are jointly and severally guilty for the murder of the deceased, who is Rampal Singh.
Okay.
That the accused number 1 and accused number 2 being educated and shared a good bond with each other. Also, accused number 2 confessed his love to accused number 1. Thereafter, accused number 2 came in extramarital affair with accused number 2. Rampal, the deceased, came to know about the extramarital affair of accused number 1 and accused number 2. So accused number 1 and accused number 2 hatched a devious plan of murdering the deceased in a cold blood, and getting rid of the victim meant removal of the hurdle between their relationships.
Okay.
When deceased saw accused number 1 and accused number 2 together in his house, deceased left the house in anger. After deceased left the house, accused number 1 went to the market and brought butcher knife, ration, vegetables, meat, medicines. In medicines, it's sleeping pills, band-aid, and painkiller, which was prescribed by Dr. Sudarshan Nayak. And the prescription date was 9th November 2021 at 11 a.m.
Okay.
When deceased reached home on 9th November 2021 at 10 p.m., accused number 1 was waiting for deceased. Then accused number 1 tried to talk and convince the deceased about his misunderstanding the situation between the accused number 1 and accused number 2, that when accused number 1 entered the house and he saw accused number 1 and accused number 2, he misunderstood the situation and he went. So accused number 1 tried to make understand the deceased that there is nothing wrong relation between accused number 1 and accused number 2. They are just friends. And to make him calm down, she sorted the situation and make him calm down. And after that, she made food, and all of them ate food and they slept. Accused number 2, after eating the food, they slept. Then, while it is assumed that accused number 1 mixed sleeping pills in the deceased food, and accused number 1 and accused number 2 can successfully, so that accused number 1 and accused number 2 can successfully complete their plan of killing the deceased. Accused number 1 and accused number 2, they used butcher knife to slit the victim's throat, and once the victim died, accused number 1 and accused number 2, they cut the deceased body into 3 parts. And the parts which were cut of the deceased body were of victim, the parts were put in the gunny bag. Later, they dig the hole under the bed, buried the victim body, and used cement tiles to cover the dig hole. Accused number 1, after getting into extramarital affair with accused number 2, behaved differently with deceased by evading the questions and giving unsatisfactory answers to deceased questions. Accused number 1 used to spend more time with accused number 2 and noticed by the informants from same mohalla, Indranagar mohalla, the informants like Pooja, Sultan, and Javed Sheikh. After no calls for few days from deceased to complain to family, complainant in a concern, complainant the brother of deceased Arun. On 19th November, he visited at deceased house and asked accused 1 that why they are not responding the call. Then accused number 1 responded in very calm way that deceased has left for Sorat on 10th November 2021 morning at 6:30 a.m. for purchasing merchandise for company work, and his phone is not reachable due to network issue. Also, she stated to Arun, the complainant, that her phone is not in working condition and she has given it for a repair in a shop. That the eyewitness Komal recorded a statement, मुझे कुछ नहीं पता, मम्मी ने जैसे पापा को बेड के नीचे डाला मुझे भी डाल देगी. That recovery of murder weapon from crime spot, butcher knife, Amba Medico's bill of 9th November 2020 of mentioning sleeping pill, painkiller and band-aid medicine prescription by Dr. Sudarshan Nayak, cut body parts in gunny bag, broken ties, deceased shirt with blood stain on it. Exhibit.
Time up.
May I please the honorable court, if I can just take 1 minute for concluding my argument.
You will lose your mark.
Okay, sir, then may I please, my co-colleague would like to continue with the second argument.
Okay.
May it please the honorable court, the prosecution seeks to your permission for proceeding towards issue number 2.
You may.
Much obliged. Whether the prosecution has been able to prove guilt of accused number 1 and accused number 2 for the offence committed under section 201 of Indian Penal Code 1860. So for it, yes, the prosecution has been able to prove the guilt of accused number 1 and accused number 2 for the offence committed under section 201 of Indian Penal Code 1860 is as follows. First, that the deceased has been caught accused number 1 and accused number 2 together inside the house. Thereafter, deceased left with their upset mind. Accused number 1 and accused number 2 made a plan to kill Rampal, that is deceased, as he is the only milestone between accused number 1 and accused number 2. Accused number 1 and accused number 2 was well aware of the financial status of accused number 2, as accused number 2 used to give gifts to accused number 1 regularly, so in the greed of better status of accused number 2 was highly attracted towards accused number 2. Agreed to the accused number 1 agreed to the execution of plan of killing Rampal, deceased, in alliance with accused number 2. On 9th November, accused number 1 went to market to bring ration, vegetable, meat. Along with this, she also bought butcher knife and medicines from Amba Medicos prescribed by Sudarshan Naik. At night, when deceased came home, accused number 1 started to execute devious plan of cold blood murder to get rid of deceased. Accused number 1 tried to have a conversation with deceased and make deceased calm down, so accused number 1 could execute step 2 of the plan, like mixing of sleeping pills in the food and serving the same. After that, which accused number 2 entered the house, and accused number 1 and accused number 2 jointly slit the throat of Rampal, deceased, and let him die. As mentioned in postmortem report, death due to loss of blood. After which accused number 1 and accused number 2 chopped the body of Rampal in 3 parts and placed the body parts in gunny bag, dug hole under the bed in deceased house only, and buried the body parts and weapons in the hole and concealed it using cement and tiles. When Arun Singh, deceased brother, arrived at the deceased house on 19th November 2021 and asked accused about the deceased, accused number 1 gave false information to Arun Singh, saying deceased has went to Surat for company work. But when deceased brother Arun inquired with PW3, that is Vichu, the proprietor of New Trend Garments and employer of the deceased, replied he is not aware of anything about the deceased as he has not seen since 10th November. That means last time he saw it was on 9th November. The petitioner complaint, based upon the evidences cited above, has proved beyond reasonable doubt the guilt of both accused jointly and severely in committing the crime, an act which attracts the severest punishment under section 201 of Indian Penal Code 1860. May I please the Honorable Court, the prosecution seeks for your permission proceeding towards issue number 3.
See how you define the intention and motive in this case. Please define.
In this case, firstly, with the status of accused number 2, accused number 1 was very attracted, as the status of accused number 2 was much higher than that of the deceased. So she, accused number 1, got attracted towards it, and in greed of better lifestyle, she agreed to execute the plan of killing Rampal Singh.
That is intention. Motive?
Motive, okay. Motive would be the better lifestyle.
Okay. Okay. Yeah. Please.
Remove the hurdle.
Okay. Not something a better life. That is not a motive.
Okay. Motive would be that she was not happy with Rampal Singh, and she enjoyed the company of the accused number 2 more than the company of deceased.
Okay. Proceed.
Okay. Issue number 3 is whether the accused has been able to prove beyond reasonable doubt that the deceased is not Mr. Rampal Singh. The deceased body is of Rampal Singh only.
How?
I'll be stating the statements now. How it is. May I proceed?
Yeah, please.
Much obliged. That is that as per the statement given by PW2, that is Komal Singh, daughter of the deceased and accused number 1. accused number 1 and 2 were seen together in deceased house, and accused number 2 was holding knife in hand. Both accused number 1 and accused number 2 were putting something in gunny bag. Second, that the chopped body parts of male body discovered was in gunny bags, which was concealed under the bed inside the deceased house. That the concealed work done under the bed was not matching with the overall flooring in the house. That as per the statement given by PW1, the deceased was last seen by PW1, that is Javed Sheikh, on 9th November 2021 at 10 p.m. when PW1 dropped deceased at home after drinks they had at the Astro Bar. That as per the statement of accused number 1, the deceased had left for Surat for the purchase of merchandise.
2 minutes left.
Purchase of the merchandise of New Trend Garments House with PW1 on 10th November 2021 at 6:30 a.m., which seems to be a false statement and contradicts the statements given by PW1 and PW3. That as per the postmortem report, the body found had contents of olpidium tartrate that the accused one had purchased from Amba Medicos on 9th November 2021. Also, the age of the deceased, according to the postmortem report, is 32, which is confirmed from the statement given by the accused number 1. That as per the statement given by the PW2, that is Komal, on asking about the deceased, the accused number 1 replied in anger that she will kill me and put me under the bed where my father is otherwise. I should keep my mouth shut. Hence, the investigation that the body found in the is of Rampal Singh. The
We are not prosecute for DNA test.
DNA test is not prosecuted, sir.
Okay, so it is all the circumstantial evidence you are drawing the attention.
Yes, and eyewitness of this PW2, Komal, the daughter of accused and deceased.
Okay. Yeah.
Sir, Your Honor, now my co-prosecutioner will be proceeding further with the chief examination.
Okay. Please.
May please the honorable court, may I proceed with the chief?
You may. Please.
Much obliged. Your Honor, I would like to call petitioner witness number 2, Komal Singh. Hello?
Am I audible?
Yes, yes, Komal.
Yes.
Komal, do you know the meaning of oath?
No.
Okay. Komal, could you please tell us your parents' name?
My father's name is Rampal Singh and my mother's name is Rebuttal.
Okay. Komal, do you go to karate classes?
Yes.
Okay. And after you woke up on screaming sound, what did you see on 9th November?
After I woke up with a screaming sound, I saw my mother, Mohan uncle with knife, putting something in a gunny bag. Then I asked about my father. Then my mom angrily said me that don't ask anything or I will put under the bed where my dad is otherwise.
Okay, Komal. And do you know VidhiTaksh?
Yes.
Okay. That's all, Your Honor. From my side for petitioner witness number 2.
Okay.
I would like to, with your permission, Your Honor, I would like to call upon informant number 1, Amol Chaudhary, for the statement.
Please proceed.
Objection, Your Honor.
Anmol Chaudhary is not in the witness list. You've been provided
Your
with
Lordship.
7 witnesses.
Ma'am, may it please the Honorable Court that the examination of the informant, Mr. Anmol Chaudhary, is crucial for this case. And as per the facts, it was specified we can use them as per the conveniency, and it is important. His statement is important for the case. So may I please request you to allow us for the same.
Prior notice has not been intimated.
Sir, actually, in fact, it was specified we can use them as per our conveniency. So that's the thing
As per your convenience in your memorials, ma'am. Witnesses mentioned in the witness list are only available for chief and cross. We have the complainant Arun Singh in the witness list.
Thank you so much, ma'am, for the update. But sir, it would be really a humble request from our side if you can just please allow us for letting us getting the statement from Anmol Chaudhary. Please,
But
sir.
he's being a complainant, how you can be admitted in the examination? He's a complainant. He has already given his all information in the police complaint. Then what the new fact he will brought?
Sir, he is an informant, and that's why his statement is very much required for this case. So there's
Has
just need
already
of
been
permission for the same.
Then from the police department, his statement is already been recorded. Now what the new fact he will brought? Is there any new fact?
Sir, his statement is not recorded in a police report. They have just provided that these two were available at the spot.
Okay.
Please, sir, just
Yeah.
much obliged, sir. May I please call Anmol Chaudhary?
Madam, have you already been provided with the list? PW 1 to 7?
Yes, ma'am, we have the data.
Yeah, so ma'am, it was very clear with the fact that PW 1 to 7 can only be taken chief and taken cross.
I totally agree with your point, ma'am. But since there is something very important for this case from his end, that's the only concept. I am just seeking approval from Honor, sir, and you to please allow me to just question Anmol Singh. It's not much, but just 2 questions, ma'am, nothing else. It is important for the case. That's why I'm focusing on it.
Your Lordship, but it is not allowed. So the counsel for the respondent would like to object.
Yeah.
Quote in the conclusion that it is not needed a new fact. We have referred the statement recorded by him. So it is not a new fact to be brought in that stage. This stage, it is not so important to bring it. If the court feels so, we'll bring him later on. Please continue with the proceeding.
Thank you, sir, for the advice. Further, Chief would be taken ahead with your permission with my co-colleague.
Yeah. Please.
May it by honorable court, may I proceed with the further chief examination?
You may.
I would like to call prosecution witness number 1, Javed Sheikh.
Am I audible?
Yeah.
Yes. May I proceed?
You may. Please proceed.
Mr. Javed, when did you see the deceased for the last time?
9th November 2021.
Okay. On 9th November 2021, at what time you dropped the deceased at his home?
Around 10:30 p.m.
What was the behavior of accused number 1, that is Surekha, while you were dropping the deceased at home?
She was waiting for Rampal.
Okay, waiting. Was she curious, or was she caring, or was she scared? Can you elaborate something?
Nothing that I noticed as so.
Okay, that's all for witness number 1. With your permission, Your Honor, I would like to call PW3, that is Vidhu.
You may.
Much obliged.
Hello.
Hello.
Yeah.
Okay. May I proceed, sir?
You may.
Much obliged. Mr. Vidhu, since when do you know the deceased, that is Rampal Singh?
About 1 year ago.
Okay. Normal for how many days you used to send deceased and Javed for Saurabh for merchandise purchase?
2 times in a month.
Okay. And for how many days was it?
2 to 3 days.
Okay. When did you see the deceased for the last time?
On 9th of November.
And when was the last time you sent the deceased to Saurabh for purchase of merchandise?
On 2nd November.
Okay. Thank you. That's all for prosecution witness 3. May I proceed with the prayers?
Please.
Much obliged. In the light of the facts pleaded, issue raised, arguments advanced, and evidences produced before the Honorable Court, the petitioner or complainant humbly prays that the accused have committed the heinous actus reus of murdering an innocent adult and attempted to murder an individual has been proved beyond reasonable doubt. That the accused had mens rea behind their actions has been proved beyond reasonable doubt on the grounds of the fear of getting separated from each other. That the accused have a mindset of such foul nature that they could go to any extent to achieve their selfish ends and are a blot on humanity has been proved by the facts that accused hatched a devious plan of murdering the deceased in cold blood and getting rid of the deceased meant removal of the hurdle between their relationship. That the magnitude and the chilling nature of the crimes of the accused is such that it has sent shivers down the spine, and the accused are a threat to others, and hence should be permanently removed from the civilized society. That the accused, now being parents, are also a threat to the welfare of their own child, and are likely to bring up with the same cold mentality or be a threat to their life even. Accused number 1 and accused number 2 have tarnished humanity by not killing the victim, but also by mutilating his body and robbing him of dignity even after death. That this case fits into the rarest of rare category, and hence the honorable court must not show any leniency to the accused and convict the accused under section 302 read with 34, 201 and 324 of IPC, sentence them to death as to do justice to the deceased and to set an example that would deter people from committing similar acts of such unimaginable, inhuman and horrific nature.
Out of both the accused, whom you find more guilty? Or both are in the equal footage?
Both are in the equal footage. But accused number 1 would be a little bit more than accused number 2, as the main steps of planning of murder was done by accused number 1, like giving sleeping pills, making the person into numbness, so that while killing there won't be any noise or screaming or any other other act from the deceased.
Okay, but those who cut the throat is not so much guilty, means you mean to say?
Actually, it is not mentioned who cut the who slit the throat, so we cannot do on that. We cannot say anything on that.
It's obviously it's obvious.
Yes.
So
Okay.
may please the honorable court, if I can state something on this.
Okay. What is new
Sir,
thing?
sir, actually, as my co-colleague said, accused number 1 and accused number 2 are jointly guilty. There is nothing, one is prior, one is more or one is less. They both are jointly guilty, because if one has done the murder and second was screening the second, then they have become equally responsible for that crime. So they are jointly responsible for this, and punishment, the prayer we have done for arrest of rare case and set them for life. This is for both of them we are asking for.
The 34 you have made for that only, but who's more guilty is to be also said, the magnify who is more in the weightage, because we have to see the ground of a humanity also. Being as a mother, she has to take care of her child also. Then
but sir, as stated in the prayer,
yeah.
Sir, as stated in the prayer, like because if the children stay with such a criminal-minded person, that there are chances that their upbringing would be of that sense only. So children staying with such a criminal-minded person is also dangerous for them, and for upcoming life also their mentality would be very different from the normal one. So we can state that they are very much guilty, and this. Sir, actually, one concern. Just my request, sir. As you said, we can use the informant further in the if needed. So can I use them further, or I can use them now? Please advise me, guide me on this, sir.
No, let the proceeding further go ongoing. Thereafter, we'll decide about it.
Much obliged, sir. Thank you so much.
Yeah.
We conclude with the petitioner side, sir.
Yeah.
The case rests on the prosecution.
This is Council VTM02. Council solicits permission to begin. Your Lordship, counsel solicited permission to begin. Much obliged. Counsel solicited permission to address the court collectively as Lordship.
Please proceed.
Much obliged, Your Lordship. Warm greetings to Your Lordship. May I please the Honorable Court. This is counsel appearing on behalf of the respondent in the instant case of State versus Surekha and another. Would Your Lordship appreciate a brief perusal of the facts of the case in hand?
Okay, please
Much
proceed.
obliged, Your Lordship. Rampal and Surekha migrated to Mumbai City along with daughter Komal for better economic prospects. Surekha started taking tuitions to supplement the income of the house. Mohan Prakash, a civil engineer and the neighbor of Surekha, gradually started developing a close relationship. On 9th November 2021, Rampal came home early in the evening. He saw Mohan in his house. He got angry and left his house. He called Javed and went to restaurant. Javed dropped him back home at 10 p.m. Accused number 1 went to purchase certain items from the shop nearby. Arun came to Mumbai City on 19th November as he could not contact his brother and sister-in-law. Since the 8th of November 2021, when accused asked her about the whereabouts of his brother, he stated that he has gone to Saurat for business purposes. After not receiving a satisfactory answer, he went to inquire about the whereabouts with Viju and Javed. Javed told Arun about the entire incident. Arun thereafter went to Vadara police station to file a missing report on 22nd November 2021. On 24th November, the investigating officer took the statement of the accused number 1 and 2. And thereafter, Komal said that she doesn't know anything. Her mother will bury under the bed just like she did her father. The investigating officer went to the house and recovered 3 gunny bags which had blood-stained dismembered parts of human body, butcher's knife, gunny bag, used tiles box, and construction tools. Thereafter, the accused were charged under section 302, 324, 34, and 201 of Indian Penal Code. If the facts are clear, the counsel seeks permission to proceed with the issues in hand.
Yes. See, all the fact which you have mentioned is all against you.
Your Lordship, the facts which I've mentioned.
You should only draw the fact of what will benefit to your side. You are just making the admission of the facts.
Your Lordship, I'll prove that in the arguments, Your Lordship.
Okay. Please proceed.
In the instant case, Your Lordship, the petitioner would be handling two main issues of law to substantiate the case of which issue number 1.A and 1.B would be handled by counsel 1, and issue number 1.C and 1.D and 2 would be handled by my co-counsel. The counsel seeks permission to proceed with issue 1.
You may.
Much obliged, Your Lordship. First issue, whether the accused is guilty under section 302 of IPC. Your Lordship, section 302 deals with the punishment for murder, and Your Lordship, section 300 deals with the definition of murder. In the case of Prashant Kumar versus State of Bihar, the accused was acquitted as no fingerprint analysis of the weapon was conducted. Your Lordship, in the present case, there was no fingerprint analysis conducted. Hence, the present accused must be acquitted. Your Lordship, the investigating officer has also failed to conduct a chemical analysis of the blood found on the butcher's knife, which makes it difficult to conclude whether it was the same weapon used. The accused cannot be convicted as there was lack of evidence. Your Lordship, the investigating officer has also failed to take the statements of two main witnesses. The informant number 2, who was the karate teacher of Komal, states that the accused number 1 used to come to drop her and stay till she would complete it. She would not leave Komal alone during her classes. The informant number 3, a news reporter, states that he had seen a man and a woman entering the house of accused number 1 with some equipment to dig and drill and some bags. Your Lordship, there used to be digging and drilling work going on for almost 2 hours daily since past few days. Your Lordship, the recovery report, the investigating officer mentioned that they found a blood-stained shirt. There was no mention about the jeans and red sneakers. Whereas in the post-mortem report, Your Lordship, it is explicitly stated in the external examination that he had worn a white shirt, blue jeans, and red sneakers. Your Lordship, there is discrepancy in the items recovered by the investigating officer and in the post-mortem report. Especially, Your Lordship, in the Indian culture, when a person enters his or her house, they remove their shoes and then enters. Whereas the body which has been recovered has the shoes on. This proves that the murder did not take place inside the house and has been committed somewhere else. Your Lordship, this proves that the offense has not been committed by accused number 1 and 2. Your Lordship, the investigating officer has also failed to show the face of the deceased to the accused number 1. The identification of the body is an important element to prove a case. There was no DNA test, as stated by my worthy opponent. There was no DNA test which took place to confirm whether it was the same deceased or not. Your Lordship, the most important aspect is of the post-mortem report, which cannot be relied upon as it is contradictory. On one hand, it states that there was full rigor mortis, and on the other hand, it states that the body has started decomposing. Your Lordship, according to the NCBI, full rigor mortis occurs between 1 to 6 hours of death and lasts up to 36 to 48 hours. Your Lordship, to prove that a crime has been committed, there has to be two essential elements which must be proved. That is mens rea and actus reus. In the present case, there was no mental intention to commit the offense, and the action which has been taken has not been committed by both the accused, as it has been clearly stated above by informant number 2 and 3. It was someone else who has committed the offense.
2 minutes left.
Your Lordship, the investigating officer has also failed to conduct the test of schizophrenia and has considered an important evidence. If Your Lordship is satisfied with the current issue, the counsel seeks permission to proceed with the next issue.
You may.
Much obliged, Your Lordship. Issue number 2, whether the accused are guilty under section 324 of IPC. Your Lordship, section 324 talks about voluntary causing hurt with a dangerous weapon. It does not come into picture only as the offense has not been committed by the said accused. As stated by informant number 2 and 3, it was someone else who had committed the offense and not the accused number 1 and 2. Hence, both the accused must be acquitted under section 302 and 324, Your Lordship. If Your Lordship are satisfied with the present issue, my co-counsel will be proceeding with the next issue now.
Then why the body received it from the same house? It is from the house only, accused house only, the body is found then.
Your Lordship, she did not know whose
How?
body was there inside the house.
No, it is when there's a digging of the house, buried the things. Person cannot be a quiet.
Your
Because
Lordship,
it takes a long time.
Your Lordship, I appreciate the question, but Your Lordship, she used to be out of the house for karate classes of her daughter
1 hour.
for
It is
3
1 hour.
hours.
For that 3 hours, this cannot be possible to dig and to bury it and then cover it up. That is not possible. Without without that, it is not a permission, or nobody can come, enter and dig the place, buried somebody's this, cut, chop this, and all these things has been sleeping pills, everything has been found.
Yes, Your Lordship. Not only about informant number 2, but also about informant number 3, Your Lordship. The informant number 3 is the news reporter who used to stay in the mohalla. He has seen some persons going inside the house.
Yeah.
May your Lord permit a minute to conclude it?
No, let the other issue to be discussed.
I appreciate it, Lordship.
Am I audible?
Please proceed.
May it please this honorable court. This is counsel number 2 on behalf of the respondent. The counsel seeks permission to address the court as a lordship.
You may.
Much obliged. The counsel seeks permission to begin with the issues. Much
Please.
obliged. Issue 1.c is whether the accused is guilty under Section 201 of the Indian Penal Code. Your Lordship, Section 201 of IPC deals with causing disappearance of evidence of offence or giving false information to screen the offenders. Your Lordship, in the case of Hanuman and others versus State of Rajasthan, it was stated that the conviction for charges under Section 302 of IPC and Section 201 of IPC can be given only after it is proved that the main offence, that is Section 302, has occurred. And secondly, the lack of knowledge and the intention of the accused may help the defense side to prove a case as a balance of probabilities. Your Lordship, if the prosecution fails to prove that the accused has knowledge or reasons to believe that the offence has been committed or an act is committed without the intention to screen the offender, then the court may set aside the conviction under Section 201. Your Lordship, in the present case, it has not been conclusively proved as of yet that accused number 1 and 2 have committed the offence. Thus, the question of hiding the evidence does not arise at all. Your Lordship, as it had been stated by my worthy opponent, that he is relying on circumstantial evidences, which states that there is no direct evidence on which he is relying, which makes his case weak. Your Lordship, as stated by informant number 2 and 3 earlier, the offence has been committed by some other person, as informant number 3 had seen a man and a woman enter the house of the accused and the deceased. And almost for 3 hours, there used to be some digging and drilling work going on, which says or which concludes that the murder has not been committed by accused number 1 and 2, and due to which the question of Section 201 does not come into picture. Your Lordship, in Surendranath Mohanty versus State of Orissa and in Palvinder Kaur case, it was stated that the prosecution must prove 2 premises. Firstly, that the offence has been committed, and secondly, that he has the reason to believe that the offence has been committed. Your Lordship, in the present case, the offence has occurred, but it has not been committed by the accused number 1 and 2. Hence, the accused number 1 and 2 cannot be convicted under Section 201 of the IPC. If your Lordship is satisfied with the present issue, the counsel seeks permission to proceed with the next issue.
Please.
Much obliged. The next issue is whether the accused is guilty under Section 34 of IPC. Your Lordship, Section 34 deals with acts done by several persons in furtherance of common intention. In the case of Pandurang versus State of Hyderabad, Mrinal Das versus State of Tripura, and State versus Babulal, it was held that to attract the applicability of this section, the prosecution must establish a common intention and that there was a pre-arranged plan in the first place. Your Lordship, in the present case, there was no common intention and there did not exist a pre-arranged plan. As it has been clearly stated by informant number 2 and 3 above, the murder has been committed by some other person and not by accused number 1 and 2. Your Lordship, accused number 1 clearly states in the fact sheet that she was against second marriage and has even told the deceased that they were just friends and had a healthy relation. Your Lordship, to constitute common intention, it is necessary that the intention of each of the accused be known to the rest of them and be shared by them. Your Lordship, in the present case, the same has not happened. And your Lordship, there were rumors about them having an illicit relationship. But your Lordship, rumors cannot conclude that there was a common intention to commit the crime. It has not been established by the prosecution that the rumors are true.
Prosecution has already proved the common intention of illicit relationship.
But your Lordship, they mentioned that there were rumors, and rumors cannot conclude that there was a common intention.
No, it has been seen together. It has been seen together.
Your Lordship, seeing together is not equivalent that they share the same ideas, and it does not say that they have committed the crime. Informant number 3 itself had stated that it was someone else whom he had seen entering their house. And for 3 years, when the daughter and the mother, that is accused number 1, used to go for karate, the same digging and drilling process was on at their house.
Maybe same accused number 1 and 2 only. by changing the clothes, changing the identity. It has happened. It can happen.
But Your Lordship, in the present case, that has not happened, and it has not been proved by the prosecution that they have changed their identity to enter their own house.
Yeah, just to misguide the people.
If they were trying to misguide the people, then the informant number 3.
34 clearly proved by the prosecution that there is a common intent.
Yes, Your Lordship, but as they have failed to take this, as the IO has failed to take the statement of informant number 2 and 3, the role of informant number 3 was that he was the neighbor and a news reporter. And he even states that a news reporter itself knows that when a person is changing their identity, as they themselves do such things to get some case report. And in the case, he knows that it was not accused number 1 who is changing the identity and entering the house. And she has also stated that she would not meet accused number 1, which shows that she had no intention of killing the deceased.
Okay, proceed.
If Your Lordship is satisfied with the present issue, the counsel seeks permission to proceed with the final issue.
You may.
Much obliged. The final issue is whether the statement of an 11-year-old girl can be relied on. Does it have any evidentiary value?
2 minutes left.
Your Lordship, Section 118 of the Indian Evidence Act deals with who may testify. It has been clearly stated that in this section, that a person of a tender age cannot testify. Your Lordship, in a journal, in an American journal, the tender age is up to 13 years. And a child of such a tender age cannot be regarded as a credible witness, as they are unable to form a distinct viewpoint and are too young to comprehend the question. And in the present case, Komal, who was of 11 years old and thus of a tender age, the child witness cannot be accepted as she was suffering from schizophrenia. And in that illness, Your Lordship, the patient tends to lie. And in the present case, the same scenario has taken place. Your Lordship,
no previous evidence has been seen. It has not been proved that she is having the schizophrenic and done the act earlier also. But see, the schedule says that between the age of 7 to 12, it depends on the maturity of the child to be noticed. And maturity of child is much better to see the evidence. See, she is just repeating the sentence given by the accused number 1. That if you tell something, you will be also being done with age like your father. So that means she is not making any new statement. She is not making any story. This is not a story. This is a real fact. What she is just copying the same what accused number 1 has told you. That inference has to be drawn.
yes, Your Lordship, but as stated in the chief examination, she herself said that if she would ask her mother further questions, then her mother would put her in the under the bed along with the father. But Your Lordship, in the previous statement, she said that मुझे कुछ नहीं पता, मम्मी मुझे पापा के साथ बेड के नीचे डाल देगी. And in
How
the
she
statement,
know that the father is under the bed? How she know? And the body
yes, Your Lordship,
received from there only.
I would get that. I would get to that part. But Your Lordship, in the statement, she even it is mentioned that the mother said, if Your Lordship could give me a minute to just answer this question.
1 minute only.
Yes, Your Lordship, much obliged. And Your Lordship, in the statement, she mentions that it has been mentioned by her that if she tells to someone else, then her mother would bury her. Your Lordship, she has been constantly changing her opinions, her statements, which itself is making her which is making a statement not reliable, and thus she is not a credible witness.
No, why she's only telling that under the bed as like father? This statement has to be given the more weightage.
Your Lordship,
How she know?
Yes, Your Lordship. Your Lordship, yes, I agree that she has specific knowledge, but then she was not the eyewitness. She had just seen a man and a woman putting something in the gunny bag. She has not mentioned that it was the same person, it was the same body, it might be something else. But your lordship, as stated, that the woman who was committing the offense told her the same thing, which made her believe that it was her mother.
Okay. Prayer.
Much obliged. Hence, your lordship, the 11-year-old testimony cannot be relied on, and it does not have any evidentiary value.
Okay.
And your lordship, she's not even an eyewitness who has seen them slitting the throat or cutting the body into pieces.
Okay. Yeah, throw the light on your prayers.
Yes, your lordship. The accused number 1, the court should find that the accused number 1 and 2 must be acquitted under section 302, 324, 201 and 34 of the Indian Penal Code. That's all, your lordships.
Okay. Any cross or?
Yes, if your lordship permits the counsel for the respondent to continue with to proceed with the cross examination under section 137 of the Indian Evidence Act.
Yeah.
Your lordship, the counsel for the respondent would like to cross examine PW2, that is Komal.
Yeah, you may proceed.
Komal, in your statement, you stated that you woke up to the screaming sound. Is it true that it was in the day?
It was not in a day.
Your uncle, the informant number 1, inquired about the whereabouts of your father, that is the deceased, only on 24th November. Is it true?
I don't recognize the date.
I shall reframe the question so that you can recollect the information. Your uncle came to Mumbai city on 19th November. Is it true?
I don't know the date.
Would it be correct to say that you saw a man and a woman with a knife and putting something in the gunny bag? Did you assume that it was your mother and Mohan uncle?
No, I saw my mom and Mohan uncle.
Did you go to karate classes or the school after the incident took place?
It happened at night. We were all at home.
The incident took place on 9th November. So from 9th November to 24th November, did you go to school or your karate classes?
Yes.
And it would be correct to state that you did not try to reach anyone, like share anything with any of your friends or teachers over there about the incident that took place in your house?
No, actually my mom said I shouldn't say anyone. I was frightened by my mom, so I didn't want to share it with anyone.
And it would be correct to state that you used to go to school and your karate classes along with your mother.
She was only there with me.
You stated earlier that your mother told you that if you tell anyone, I would bury you along with your father under the bed. And even after that, you trusted her and went for your karate classes?
I had no choice.
No further questions, Your Lordship. Your Lordship, the counsel for the respondent would like to cross-examine the prosecution witness number 3, Viju.
You may.
Much obliged.
Am I audible?
Yes. Is it true that Rampa left early from work on 9th November?
Yes.
Would it be correct to state that Rampal did not come to work from 10th November?
Yes.
And is it true that you used to send him to Surat because you trusted him along with a huge sum of money?
Yes.
Did his absence matter to you?
Not that much, because he said that he was not well on 9th of November.
In your statement, you have not mentioned anything like that. Is it true?
Like what?
Currently, you just stated that he mentioned that he was unwell, due to which he did not come to work.
He went early on 9th of November. Okay, after giving that statement that he is not well.
So his absence did not matter to you.
No.
Then why did you trust him so much? Then is it true that you trusted him even after his absence didn't matter to you?
Yes.
And you did not try to inquire about his whereabouts because you trusted, even after he did not come to work for a very long duration.
No.
No further questions, Your Lordship.
Okay.
Your Lordship, my co-counsel would proceed with the cross-examination.
With your Lordship permission, the counsel for the respondent would like to cross-examine prosecution witness number 1.
You may.
Obliged, Your Lordship.
Can you please be louder?
Yes. Mr. Arun shared everything with you. Is the witness there?
Please wait.
Yes, Your Lordship.
Yes. Yes.
Mr. Arun shared everything with you, didn't he?
Sorry, can you elaborate it?
Yes. Mr. Arun shared everything with you, didn't he?
Yeah, of course. I, Arun Dilip Singh, and my occupation is I'm a salesman in Panchayat present.
In the fact sheet, it is mentioned that the deceased had a drink with you, but in your statement, you stated that you have no count as to how many drinks did he have. Is it true?
Excuse me, speaker 1, did you call Arun Singh, right?
Javed Sheikh,
Oh, Javed Sheikh will be
witness
right
number
here.
1.
Arun
Silence in the.
Hello.
Is the witness number 1 there?
Yes.
Mr. Arun shared everything with you, didn't he?
By everything, whatever he mentioned, yes.
In the fact sheet, it is mentioned that the deceased had a drink with you, but in your statement, you stated that you have no count as to how many drinks did he have. Is this true?
Yes, this is true.
Would it be correct to say that you were involved in the plan of killing Rampal because of jealousy?
No.
Mr. Arun came to inquire about the whereabouts of Rampal on 22nd November. Is that true?
I don't really recall the date, but he did came and asked me about Rampal.
Would it be correct to say that you saw Surekha and Mohan in the garden?
Yes.
No more further questions, Your Lordship.
come to the conclusion. Conclude your argument.
Yes, Your Lordship. Your Lordship, as stated by Mr. Javed, that is PW1, he said that he does not have a count of how many drinks he had. And in the fact sheet, he mentions that he had a drink, which itself makes it contradictory. And we cannot trust on this witness. Your Lordship, PW2, that is Komal, is unable to recollect anything which has taken place on that incident. Then how is it possible that she could exactly recollect everything without being coached or tutored in front of the police? And how is it possible that for almost a very long time, that is for 5 days, she did not share anything with her uncle and went with her mother for her classes and her school, trusting her, even after she knows that her mother would kill her someday? And Mr. Vij, that is PW number 3, states that he trusted him and sent him to Surat for his merchandise with a lot of money, with a huge amount of money. But then later he tells that his absence didn't matter. This itself shows that it is contradictory and all the 3 witnesses cannot be relied on. That's all, Your Lordship.
Okay. Hmm. Any rebuttal from prosecution?
Yes, my lord, with your permission, can we proceed for the rebuttal?
Yeah, only one.
Only one. Okay. First thing is that if the murder had happened at night, 11 to 1, that is mentioned in postmortem report, then where was the body?
Your postmortem report is not mentioning the liquor contents.
Sorry?
Liquor contents in the viscera is not been mentioned in the PM report.
Yes, actually, it is not mentioned because alcohol is not found in the body after for 24 to 48 hours. And this postmortem report was done way before, way after the crime. Like a crime was committed on 9th and the postmortem report was done on 25th.
There is some discrepancies there.
Yes. Okay. May I proceed further, sir? My lord?
Yeah.
When the murder is committed at night, like it is given in the postmortem report that it was committed between 11 p.m. on 9th November to 1 a.m. on 10th November. So, where was the body kept even after the murder till the time of the karate class for the kid, like Komal? As my learned counsel said, there was a full rigor mortis. Then I assume that rigor mortis was even present even at that time also, between the crime scene, crime time and during the classes.
Very true.
And at that time also, the decomposition should have been started, because I don't think classes would be early in the morning, like 6 a.m. or 5 a.m. So
Obviously.
there would be some smell of the rotten body, that would be smelled by neighborhood also. So it is, I would like to say that it is not true that the body is buried by someone else in those 3 hours, because there should have been something, right?
Others cannot enter in the house and bury it. That is the inference which drawn by the respondent is not been accepted.
Yes. And my learned counsel also talked about the fingerprint. I guess there was enough time for the accused 1 and accused 2 to remove the fingerprints, as there are many like fingerprint removers are present. Like we can use acid or acetone that is used for nail polish remover, which can be easily removed for fingerprints also from the weapon.
Okay.
And as my yeah, that's it from my side.
Okay.
Your Honor, the counsel for the respondent would like to answer the questions raised.
Only one.
Yes, Your Lordship. Your Lordship, as my worthy opponent stated that there was a discrepancy in the postmortem report, then how can one rely on the report itself? The prosecution itself has created a doubt. Secondly, as mentioned
Not a
that
doubt. It is not a doubt. It may say that it may be not been noticed, that alcohol has been not been noticed, as the court has been known to know that when the body may cut, maybe that has not spread in the blood. So that can be happened.
But Your Lordship, as undigested matter has been found out, there will be there might be at least some traces of liquor which should have been found, which Dr. Ajay Matre has failed.
But it has been buried for so many days, so maybe it is decomposed and diluted.
Yes, Your Lordship, I'll get to that part. The thing is, the postmortem report is contradictory. How? That I'll explain. The report mentions that it had started decomposing, and on the second hand, it states that there was full rigor mortis. But Your Lordship, full rigor mortis occurs only 1 to 6 hours after the death and lasts up to 24 to 48, 36 to 48 hours. And Your Lordship, if the postmortem report states that the death has taken place on 9th November, then how can full rigor mortis stay till 25th or 24th night? That itself shows that the postmortem report is contradictory. And Your Lordship, as stated by my worthy opponent, that there was no smell. Your Lordship, as stated by informant number 3, there was someone else who has committed the crime. They have added layers of cement and tiles, which prevents the body to come in contact with the air, which makes it difficult for the body to decompose faster. And thus the process of decomposition becomes slower, which makes it true that rigor mortis was there, which is the third stage, which happens after the death has taken place. And decomposition is the 5th stage. There is one more stage which comes in the between, that is livor mortis. And in that, the muscles are not completely stiff. There are some parts which are stiff, but some muscles are normal. They get loosened up. And Your Lordship, informant number 3, he stays in the mohalla. And mohallas are not too big. So they
Time
know.
up for rebuttal.
If I can conclude, Your Lordship. Much obliged.
Court has satisfied.
Much obliged.
May I please the court for सर को सुनाइए देना सर. May I please the court for providing us time for proceeding with Sir Rebuttal? Please, sir.
No extra rebuttal will be provided.
I said one only.
Your Honor.
The teams may leave. The results will be announced by 4 p.m.
Okay.
VTM 02, please leave. VTM 02, please leave the meeting. VTM 02, researcher, please leave the meeting.
Good afternoon, everyone. So we shall be starting with the semi-final round of the Moot Court. We shall be having the semi-final round today, that is 11th of February 2022. The rules for the semi-final rounds are each team shall be given a time of 30 minutes. The bifurcation of 30 minutes would be 18 plus 12 minutes. 18 minutes for argument and 12 minutes for chief and cross respectively. In the 18 minutes, the mooter 1 shall have his or her argument for 9 minutes, and the mooter 2 shall have his or her arguments for the next 9 minutes. Rebuttal and sur-rebuttal shall be at the discretion of the judges. Marks shall be deducted for the extension of time without the permission of judges. If the permission for rebuttal or sur-rebuttal is granted, the time for rebuttal shall be 5 minutes, and the time for sur-rebuttal shall be 3 minutes. The participant shall adhere to the black and white uniform dress code when present in any moot court room during the competition. The participants are requested to keep their videos on. Any violation in the rules shall lead to reduction of marks. You are good to go. The prosecution starts first.
A very good afternoon. The counsel will be speaking on behalf of the prosecution. The counsel seeks permission to address the bench as your honor.
You may.
Much obliged, Your Honor. Your Honor, if Your Honor is well versed with the facts and issues of the case, The counsel humbly seeks permission to move ahead with the contentions at hand.
You may.
Much obliged, Your Honor. Your Honor, in the current case, there are three issues. The first is whether the accused is guilty of committing the offense of murder. The second is whether both the accused have committed the crime in furtherance of a common intention. And third is whether the accused are guilty of causing disappearance of evidence or giving false information in order to screen the offender from legal punishment. Your Honor, counsel number 1 will be speaking for the third issue, and my co-counsel, counsel number 2, will be addressing issues 1 and 2 combined. Your Honor, the counsel humbly states in the affirmative that the accused are guilty of causing disappearance of evidence and giving false information in order to screen the offender. Section 201 of the IPC reads as follows: whoever, knowing or having reason to believe that an offense has been committed, causes any evidence of the commission of that offense to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting to the offense which the accused knows or believes to be false, shall, if the offense which he knows or believes to have been committed is punished with death, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Your Honor, in case of Sukhram versus the state of Maharashtra, 4 ingredients were established in order to prove the offense under section 201 of the IPC. The first is committal of an offense. The second is whether the person charged with the offense under section 201 had knowledge or reason to believe that the offense was committed. The third is person charged with the said offense should have caused the disappearance of evidence or have given false information relating to it. And lastly, the act should have been done with the sole intention of screening the offender. Your Honor, by stating the facts and circumstances further in the contentions, the counsel seeks to establish that all of these ingredients were satisfied. The very first ingredient is committal of an offense. Your Honor, Mohan and Surekha used to often meet in Rampal's absence. Even on the 9th of November, Mohan was in Rampal and Surekha's house at 5 p.m. It is humbly brought to the attention of the Honorable Bench that 9th of November 2021 was a Tuesday, which is a working day. Mohan usually returned home after work after 7 p.m. in the evening. The question that arises now is, Your Honor, what was Mohan doing at Rampal's residence during his work timings with Rampal's wife in Rampal's absence? Moreover, when Rampal rang the bell multiple times to enter his house, Surekha did not open the door for around 5 minutes. And when she did, she could not hide the fact about herself and accused number 2 anymore from her husband. As soon as Rampal left, Surekha went to purchase a few things in order to prepare for the commission of the said crime. She bought the knife and the sleeping pills. She slipped the sleeping pills in Rampal's dinner, and as soon as he was out of his senses, Mohan and Surekha completed their task of eliminating the one barrier that lied in their way. Surekha also lied about Rampal going to Surat for purchasing the material for business. Rampal was always accompanied by Javed, Your Honor, for all his work trips. Both Viju, the proprietor, and Javed, his colleague, were unaware of Rampal's whereabouts. Finally, when questioned, Komal, Rampal and Surekha's 11-year-old daughter, admitted that her father was killed and buried under the bedroom floor. When the police officers went to investigate, they found the body exactly where witness number 2 stated that the body would be. Therefore, Your Honor, the counsel humbly submits that the first ingredient of committal of an offense under section 302 has been satisfied. Moving on to the next ingredient, the fact that the accused had made a complete preparation to commit the crime and to get away with it leads us to understand that they had complete knowledge about the same. Preparing to buy meat in order to purchase a butcher's knife clearly fits the chain of events that constituted the commission of the said crime. However, in doing so, the accused have missed out a major loophole. Normally, a person planning to cook meat gets it cut from the butcher itself. This is because it takes a lot of skill and knowledge to identify how to cut meat, which part is edible and which part does not have any sinew. It is thus seen that the accused had complete knowledge and reason to believe that the offense has been committed. In spite of all of that, both the accused have lied about the victim's whereabouts and have tried to disappear all the evidence, which included the body, which was severed into pieces in order to dispose it of without leaving any traces. All the evidence found shows that the second ingredient also has been satisfied and that they had complete knowledge about the same. Your Honor, the third ingredient is whether with that knowledge and belief, they themselves have committed the crime of disappearance of evidence or given false information relating to it. In the current case, Surekha has stated that she is unaware from where the body came and how did it appear there. However, the counsel would like to humbly remind the defense that the body was found in the accused's home under her own bed, buried under the floor. There is absolutely no way that she was not aware of what was going on at her own place of residence. Accused number 1 also provided false information that Rampal had gone to Sorat and since then never returned. Apart from that, all other evidences such as the bloodstained butcher's knife, the cement bag, the boxes of used tiles, etc. were found and recovered from the crime scene. Therefore, the counsel submits before the Honorable Court that the third ingredient has been established as well. Coming to the last ingredient, whether the crime was done, whether it was the disappearance was caused in order to screen the offenders from legal punishment. Your Honor, the victim's body was buried under the bed with the sole purpose of getting away with the crime. No one can think of first committing a murder and then burying the evidence under their own bed. It would be very difficult to even think.
2 minutes left.
It would be very difficult to even think that a person can go to such an extent. There have been many cases in the past wherein the victim was burnt or thrown away in the water body. Hence, it would have been highly unlikely to frame charges against both the accused if the body were not found. It can be easily determined that the same was done with the sole purpose of screening the offense. This is proved by witness number 2's statement where she reiterates that she saw her mother and accused number 2 with a knife and gunny bag in their hand, and also Surekha admitting to her daughter that she killed her husband and threatened to kill her too and put her under the bed where her husband lies if she asks any more further questions about the same. Therefore, Your Honor, the counsel humbly submits that the fourth ingredient has been satisfied as well, and hence it is submitted before the Honorable Court that the accused parties have committed the offense of causing disappearance of evidence and giving false information with the sole intention of screening both the offenders from legal punishment. Your Honor, if Your Honor is satisfied with the statement of contentions for this issue, counsel number 2 seeks permission to begin with the contentions for issues 1 and 2 combined.
Yes. Please proceed.
Much obliged, Your Honor.
The counsel seeks permission to address the bench as your lordship.
You may.
Much obliged. Issue number 1. Whether the accused are guilty of the offense of committing murder. Section 302 of IPC entails about murder. In the present case, as per the facts of the various events that took place and also as per the statement of the witnesses, it can be observed that the actions of Surekha and Mohan matches all the constituents of a murder. The essential ingredients of a murder include intention. There must be mens rea to cause death. Knowledge. The act committed must be with the knowledge that it would cause death. Bodily injury. The bodily harm caused must be with the intent that would likely cause death. It can be easily deduced by various statements of the witnesses for how close Surekha and Mohan had grown over time. As per the events, Mohan used to give Surekha frequently, and Surekha, despite being married faithfully to Rampal and being well aware about the consequences of accepting such gesture, went ahead for it. Mohan even confessed his love for Surekha, and Surekha showed her affection to the same. This clearly speaks a lot about their illicit relationship. To add further, Mohan also used to visit Surekha in absence of Rampal, to which Surekha never protested and gladly invited him. Why would a man gift a woman on frequent basis? Why would be someone so generous of one's company unless he had feelings for her. The alleged accused found an excuse in the absence of Rampal and became closer, thereby forming an illicit relationship. But their wishes were short-lived, as Rampal was in the way, and the only manner through which they could fulfill their wishes was to ensure that he was out of the picture. Here, the council would like to take a reference of a precedent to support the current contention. In the case of Nazar Singh versus State of Punjab, the Lordship stated that no husband would make a propaganda of illicit relationship of his wife, especially when he had a minor children. But be it that as may be, the very fact that the accused tried to wrongly divert the complaint and the police to conceal the reality to her husband is a good reason to support the story of her illicit relationship with the other accused, which led to a conspiracy between them to murder the husband. Similar instance can be observed here as well. It is to be observed that her behavior towards Rampal had changed in the times when she got closer to Mohan, and when she was confronted by Rampal with the rumors, she didn't give any satisfactory or conclusive explanation. They had a clear mens rea of getting Rampal out of the picture when one day he returned home early and found them together. The door was opened after 5 minutes. The repercussions that came after made it evident to them that things were beyond their control, that they were caught and something had to be done. Once again, to support the contention, rather than taking efforts to clear the misunderstanding between herself and Rampal, Surekha went out to purchase the necessary items required for murdering Rampal and getting out of the mess. Which sane person would stroll out to purchase groceries and medicines during such a marriage-threatening circumstance? Instead, she made no attempts in defense and planned for such a vicious act. She didn't even give a single call to Rampal during these events. With the intention established, the purchase of butcher's knife, which was indeed the weapon that was found to have been used on Rampal's body, it was very evident that Surekha did not just have intention, but had clear knowledge as well as the mindset to cause bodily harm to Rampal on his return, which would eventually cause his death. Once again, the council would take a reference of a precedent. In Jai Prakash versus Delhi administration, the court defines intention as the intention is the conscious state of mind that plans to an act to achieve the desired objective. Various items which were recovered after the investigation, such as the gunny bags, the tiles box and cement bag being used, clearly tells us that she had received the help of Mohan. Being a civil engineer, acquiring such materials becomes very easy, and as per any common rationale, the dismembering of body parts of Rampal could not have been done by Surekha alone, as it takes a lot of strength to separate human body parts. In Tanviben versus State of Gujarat, the Honorable Court held that if the evidence of the murder is reliable, the conviction can be made even if the motive is not established. Even in the State of UP versus Lakhan, the court held that the motive is something that is locked up in the mind of the accused, and therefore it is to be adjudged from the circumstantial facts of the case. The intention behind the commission is also to be inferred from the same. This same theory can also be confirmed with the statement of Surekha and Rampal's daughter, who said in a scared tone that, "I don't know. If I say something, my mom will bury me under the bed, just like how she did to my father." This is another statement that supports and confirms the act of murder and acts as a circumstantial fact. To invoke section 34 IPC, it is to be established that the criminal act was done by more than one person in furtherance of common intention of all. Therefore, there was common intention on part of several persons to commit a particular crime, and that the crime was actually committed by them in furtherance of the common intention. The fundamental factor is a pre-arranged plan to execute and achieve the desired result. It was held in the case of Gopinath versus State of UP that the pre-arranged plan can be proved either from the conduct or from circumstances or from incriminating facts. Common intention does not mean the similar intention of several people. To constitute common intention, it is necessary that the intention of each one of them to be known by the rest one of them and shared by them. In the present case, accused number 1 and accused number 2 were having an illicit relationship. As much as both accused number 1 and accused number 2 express their affection and confess their love for each other, as it is mentioned in the fact sheet, the fundamental factor of common intention, that is a pre-arranged plan and its further execution, has been very well established by the circumstantial evidences. Accused number 1 brought strips of sleeping pills and butcher's knife before the deceased returned home at night. Further, as a part of pre-planning to reach the desired result of killing the deceased, she bought meat. This clearly shows her intention and that he or she is under the stress, and it is a basic tendency of human being. And moreover, the presence of gunny bags and cement bags, tiles box, all of these circumstantial evidences make it crystal clear that none other than accused number 2 is the one who helped accused number 1 in arranging all of these things which were used in committing the heinous crime. All these evidences are more than enough to establish the pre-planning of the said crime, which further proves the common intention of both of them. Hence, it is humbly
2 minutes
submitted.
left.
Hence, it is humbly submitted by the prosecution that the prosecution has successfully proved beyond reasonable doubt the common intention of the accused by bringing on record that the said acts were committed by several persons in furtherance of their common intention. If your lordship is satisfied with the current contention, the council seeks permission to move forward with the prayers.
You may.
Much obliged. In the lights of argument advanced, authorities cited, and the facts stated, the prosecution humbly submits in this honorable court may graciously adjudge to find and hold accused guilty for commission of offence under section 302 read with section 34, to find and hold the accused guilty for commission of offence under section 201, and to convict the accused for the said charges, and to pass any order that it may deem fit in the interest of justice, equity, and good conscience, all of which is most humbly prayed. That is all.
But there is two things to be noted here. Is that DNA report was not been included. Second thing is that the mobile of a deceased person has not been verified for the location. So that has to be brought into this. The court is given the direction to do these two things to furtherance of this evidence. Yeah.
Yes, your lordship. If it may please the court, then the prosecution would bring all of this evidence that is being asked by the honorable court in the next one.
Your Honor, the counsel seeks permission to begin with the examination in chief.
Yes, please.
Much obliged, Your Honor. Your Honor, the first witness that we would want to call upon is witness number 7, Arun Singh.
Yeah, please.
Mr. Arun Singh, am I audible?
Please wait. Please wait.
Yes, ma'am.
Sir, could you please state your full name and your occupation?
I, Arun Dilip Singh. My occupation is I'm a salesman in Panchayat present.
So how would you describe your relationship with your brother Rampal Singh?
Yeah, we were very attached and we were very familiar. And also he was like my father because he was my elder brother.
Did you happen to contact him very frequently? Did you happen to contact him every day?
Yeah, I used to call him on a daily basis.
Okay. Arun, what was the last day when you had a contact with him? On which date were you able to establish a contact with him?
The last date was on 8th November.
Okay, that's all.
Thank you.
Your Honor, the second witness that we would want to call upon is witness number 3, Viju, the proprietor.
Granted.
Much obliged, Your Honor.
Hello.
Yes.
Yeah. I'm audible?
Yes. Could you please state your full name and your occupation?
I'm Mr. Viju, owner of Nutrient Garment.
Mr. Viju, were Rampal and Javed your employees?
Yes.
How long were they under your employment?
Rampal was from 1 year and Viju was from 7 years.
Did you send them very frequently for work trips to Surat?
Yes.
When was the last time you sent them to Surat?
I don't recollect now.
Okay, that's all. Your Honor, the council seeks permission to call upon witness number 1, Javed Sheikh.
Permitted.
Much obliged.
Am I audible?
Yes. Sir, could you please state your full name and your occupation?
I am Javed Sheikh and I'm the manager of Nutrient Garment Store.
For how many years have you been working as a manager for New Trend Garment Store?
As a manager precisely for 5 years.
Okay, and in total?
In total, I have given my years of 7.
Okay. For how long have you known Rampal Singh?
Around a year.
Okay. Is it true that both of you went for business trips to Surat very often?
Yes.
How long? What was the duration of the trips?
Sometimes it would take around a month, sometimes more.
Were you able to establish a contact with your family when you were on, or when you all were on the business trip?
Yes.
Can you please narrate what happened on the 9th of November 2021?
On 9th of November, Rampal called me around 7:30 p.m. and he sounded quite stressed. He asked me to meet him at a resto bar. And when I met him, he was quite angry and stressed as he saw Surekha and Mohan Prakash together in his home. And we just had a few drinks and then I dropped him off at his place around 10 p.m. because he wasn't in a good mental state.
Did you happen to meet Mr. Rampal Singh again?
No.
Were you aware about his whereabouts beginning from the 10th of November 2021?
No.
Okay, that's all. Your Honor, the next witness that we wish to call upon is witness number 2, Komal.
Granted.
Much obliged, Your Honor. Komal, could you please state your full name and your age?
Komal Rampal Singh. I'm 11 years old.
Komal, do you understand what is the meaning of oath?
No.
Okay, so Komal, right now I will be asking you a few easy questions and you will have to give the right answer. You will have to state what is the truth. That is oath. You cannot speak lies when you are here. Is that understood, Komal?
Yes.
Okay. Komal, in which class are you? In which standard are you in?
6th standard.
Okay. And Komal, do you have any other extracurricular activities that you take part in along with your school?
Yes, in karate.
Okay. So you go to karate classes very frequently?
Yes.
Okay. Komal, were you at home on 9th of November?
Yes.
Okay, Komal, can you narrate the incident of 9th of November?
At 9th of November, my mom cooked food for us. We ate our dinner. I went to sleep. Then I woke up with a screaming sound. I saw my uncle with knife. My mom. I asked what they were putting something in a gunny bag. Then she angrily said, "Don't ask anything, or she will."
Komal, you're not audible. Hello, am I audible?
Hello.
Yes, Komal. Komal, can you please repeat what you just stated? We could not hear you.
Yes. So my mom. So my mom cooked dinner for us. We all ate our dinner. Then I went to sleep. I woke up with a screaming sound. Then I saw Mohan uncle with knife, my mom, and they were putting something in a gunny bag. I asked, then my mom angrily said, "Do not ask anything, or she will put me under the bed where my dad is otherwise."
Okay, Komal, that's all. Your Honor, the council seeks permission to call upon investigating officer Jayant Pawar.
Please.
Much obliged, Your Honor.
Hello, am I audible?
Yes. Sir, could you please state your full name and your designation?
Investigation Officer Jayant Pawar.
Sir, is it true that the FIR was lodged on 22nd of November 2021?
There was a missing report which was filed on 22nd of November. The FIR was filed on 24th of November.
Okay, sir. Noted. Sir, can you state what all evidences did you find at the scene of the crime?
There were 3 goonie bags with bloodstain on them, a butcher knife, a box of broken tiles, construction tools, a goonie of cement.
Okay, sir, that's all. Your Honor, the council has asked these questions to the witness to establish the fact that the accused have clearly lied and have also caused disappearance of evidence. The accused states that her husband's phone was old and it did not have a proper battery. Hence, they could not contact him. They could not establish any contact with him. However, as per Javed Sheikh's statements, on the 9th of November, Rampal called up Javed and asked him to come to the resto bar. And therefore, this is proof that this is also lies. Similarly, Javed has very clearly stated that they could contact their family members while on work trips. Here, Surekha mentions that she could not contact her husband whenever he was on any work trip. Hence, again, they have lied. Also, all the prima facie evidence, that is 3 gunny bags, a bag of cement, a box of broken tiles, and the butcher's knife, all form a prima facie evidence that goes against the accused in this case. Also, the statement provided by witness number 2 clearly mentions that she had seen her mother and accused number 2, Mohan Prakash, with the knife and the gunny bag. They were putting something in the gunny bag, and she told her daughter that she would kill her and put her under the bed too, as she did with her husband. Therefore, Your Honor, the council humbly submits that the accused in this case are guilty under section 201.
Okay.
The counsel seeks permission to allow counsel number 2 to proceed with examination in chief.
Proceed.
The prosecution would like to call upon Javed Sheikh.
Hello.
Yeah, can you please state your name and occupation?
I'm Javed Sheikh and I'm the manager of Nutrient Store.
So I have two questions for you. First, has it ever been during the trips that you had with Rampal that his phone was not reachable?
Not that I recall.
Another question. During the time when you met with Rampal on 9th of November, what was his outfit?
I don't recall.
That is all. The prosecution would now like to call Kashinath with your lordship's permission.
Okay, please proceed.
Am I audible?
Yes, you are. Can you please state your name and occupation?
I am Kashinath,
Cross-examination.
51 years old, owner of Amba Medical.
How often did Surekha used to visit your medical shop?
I don't know.
Okay.
Quite often.
And how often, when she visited your shop, did she buy sleeping pills?
Yes.
I'll repeat my question. Whenever she visited your medical shop, how often did she used to buy sleeping pills?
Quite often.
And in whose name was the prescription of sleeping pills?
Dr. Sudarshan Naik.
No, my question is that in whose name was the prescription? Like, was it for Surekha? Was it
Surekha.
for... Okay. That will be all. That is all from prosecution side, your lordship.
Okay. Now, respondent.
Please the Honorable Court, I, Counsel number 1, along with Counsel number 2, on behalf of the defense, Surekha Singh and Mohan Prakash is appearing before this Honorable Court in the case of State of Maharashtra versus Surekha Singh and Mohan Prakash. The counsel would like to address the bench as your lordship.
You may.
Much obliged. If the Honorable Court is well versed with the facts of the case, the counsel would like to proceed with the contentions. Much obliged. Much obliged. The counsel would like to submit that the first issue is in negative, that the accused are not guilty for the charges under section 302, 34, 324 and 201 of the IPC. It is humbly submitted that the offense, alleged offense, falls under the subclause number 1 of section 300. Subclause number 1 of section 300 read as, except in the cases herein after accepted, a culpable homicide amounts to murder if the act which is done by which death is caused is done with the intention of causing death. Your Lordship, according to section 301 of IPC, intention plays a very vital role in the commission of murder. The counsel would like to define intention as determination to perform a particular act or to act in a particular manner for a specific reason or an aim to do it. The counsel would like to further state that a commission of murder takes place due to two reasons. That is when it has a mens rea as well as the actus rea. In the present case, the mens rea can be established because there was the mens rea can be established only when there is a criminal intent and a guilty mind. the various elements of mens rea, the council would like to highlight various constituent elements of mens rea. The mental condition with the thought process which consists of motive and volition. Motive is just a reason for intention, and good or bad motive plays a vital role for determining the punishment, but also it does not safeguard the accused. The council would like to state that the council would like to draw your lordship's attention to the Latin maxim, actus non facit reum nisi mens et rea. In simple word, it means that a person is guilty for a criminal act only if the act shall be include the criminal intent. Therefore, the council would like to further proceed that the maxim has been integrated into the Penal Code 1860 in two basic ways. That is, first is through the express inclusion required by the state of mind, that is under the definition of offense, and secondly, through the general exceptions enumerated in the chapter 5 of the code, in which it clearly mentioned that deny the existence of mens rea. Hence, when there is a denial of mens rea in any act, this Latin maxim is applicable. The council would like to draw your lordship's attention in the case of R. Balakrishnan Pillai versus State of Kerala, in which the Supreme Court held that criminal guilt would attach to a man for violation of a criminal law. However, the rule is absolute and subject to limitations. In the Latin maxim, it signifies that there can be no crime without a guilty mind. To make a person criminally accountable, it must be proved that the act is forbidden by law and by his conduct. The conduct should be accompanied by legally blameworthy attitude of mind. That includes the physical element and the mental element. That is also called as the mens rea and the actus rea. In mens rea, the council would like to say that an important thing to consider is the intention of the facts and circumstances and the knowledge of the act. A question of intention is always a matter of fact, whereas the knowledge describes the awareness of oneself. The council would like to state that an intention is an indicative of purposefulness of an act, and where a person intends to do such an act, he should be held liable for a resulting consequences. It is also submitted that intention is treated as the highest degree of mens rea, but in the present case, there is a purely lack of evidence which shows that the mens rea was established. The council would like to further state that the knowledge signifies the awareness and certainty of the effect. In the instant case, the council would like to submit that there was no motive and knowledge about the alleged crime, and accused number 1 was not aware about the dead body below her bed. The council would like to focus on the actus rea part now. The council would like to state that actus rea is a wrongful act, and in the instant case, it is the physical conduct of the accused to do that act. This can be established by two ways. That is the discovery of the crime articles and the witness statement by PW2. The council will be dealing. The council would like to address the first part of the discovery of the crime article in the cross-examination and prove its point over there. The council would like to further proceed to the statement of PW2. According to the fact sheet, the facts mentioned by PW2 were, मुझे कुछ नहीं पता, मम्मी ने जैसे पापा को बेड के नीचे डाला, मुझे भी डाल देगी. But as per the statements of PW2 in the witness statement, she mentioned that my mother cooked food. We all ate our dinner, and when I went to bed, I woke up to the screaming sound. I saw my mother and Mohan uncle had a knife, and they were putting something in a gunny bag. When I asked about Papa, Mummy said angrily she will kill me and put me under a bed where my father is otherwise. I should keep my mouth shut. Council would like to submit that Komal was very young to understand and differentiate between what is a right and wrong at the tender age of 11 years. Anyone could have brain fed her at that age. The PW2 was also not in a mental state of mind, and she was also diagnosed with the early stage of schizophrenia. And due to her medical condition and early stage, a daily dose of the drug zolpidem tartrate was being treated. and was required. Similarly, a dose was administered to her on the 9th of November as well, after having the dinner. The council would like to pose a question to itself that when a minor girl is under the influence of a sleeping pill, is it logical or is it even possible for her
2
to
minutes left.
Is it possible for her to wake up to a screaming sound? The purpose of sleeping pill is to put oneself to deep sleep so that she does not get disturbed. And it is quite difficult to understand the logic where it is mentioned that she woke up to a screaming sound. Also, the council would like to pose that the various symptoms of schizophrenia are lack of sleep, insomnia. That is why sleeping pill was a must. Therefore, the council would like to further state that it is better that 10 guilty escape than 1 innocent suffer. According to William Blackstone, it is rightly said that when there are instances where the accused is not to be held guilty due to lack of evidence, a court should not convict an innocent, as he will have to suffer without any crime he has committed. The council would like to further proceed to the common intention.
Can you just reply 2 things where the body is found?
Your Lordship, the body was found beneath the bed.
And where the Komal has stated?
Your Lordship, the council number 2 will be dealing with this question in our further submissions.
No, just answer where she has put it, that where her father is?
Below the bed.
Okay, that's it. Okay.
Much obliged. It is submitted that in the present case, no common intention lies between both the parties, as a common intention would require, under the ambit of section 34, there will require a common intention to commit a criminal act, and there must be participation of all persons in doing such an act. The council would like to state that just a piece of evidence, and does not create a substantial. The council would like to just conclude this statement with your Lordship's permission.
10 seconds.
Section 34 implies and pre-arranged meeting of minds. Therefore, the council states that there is sharing of purpose, which is lacking in the present case. Therefore, the accused number 1 and number 2 cannot be held guilty for the offense under section 34.
Further,
the rest of the issues will be dealt by my co-counsel.
Yeah.
The council would like to address the bench as your Lordship.
Proceed.
Much obliged. The council would like to submit before your Lordship that circumstantial evidence present in this case is not sufficient to prove the guilt of the accused. The council would first like to define circumstantial evidence as the evidence based on inference and not on personal knowledge or observation, and in a situation where witnesses are not present. The council would like to state that where a case is based mainly on circumstantial evidence, the court must satisfy itself that the various circumstances in the chain of evidence should be clearly established, and the complete chain must be such as to rule out a reasonable likelihood of the innocence of the accused. The council would like to state that the circumstantial evidence which forms the basis for this entire case cannot be solely relied upon so as to infer that accused number 1, Surekha Singh, and accused number 2, Mohan Prakash, have committed the offense of murder. The same shall be established by understanding the various crucial elements present in this case. Before diving into the same, the council would like to take this opportunity to state what the law says with regard to relying upon circumstantial evidence in order to draw a definite conclusion. While attempting to convict on the basis of circumstantial evidence alone, the court must be satisfied of the following 5 things, and the same should be proved by the prosecution. The circumstances from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be inconsistent with the hypothesis of the guilt of the accused. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one that is to be proved. There must be a chain of evidence so complete as to not leave any reasonable ground for the conclusion consistent with the innocence of the accused. Here, the council would like to draw your Lordship's attention that None of the above mentioned things have been proved against the accused by the prosecution, as there is no conclusive evidence proving the crime is done by the hands of the accused. The counsel would also further like to state that the offense alleged is required to be proved beyond all reasonable doubts. First, the counsel would like to define a reasonable doubt as not an imaginary, trivial, or a merely possible doubt, but a fair doubt based upon reason and common sense. In criminal cases, the burden of proof is on the prosecution, and the standard required of them is that they prove against the defendant beyond any reasonable doubt. The counsel would thus like to state that the circumstantial evidence in this matter does not prove beyond a reasonable doubt that the act must have been done by the accused. The counsel would like to state that the doubts must be actual and substantial doubts, and they should not just be out of a mere vague apprehension. To support this, the counsel would like to quote the case of Hanumant Govind versus the state of Madhya Pradesh, in which it was held by the Supreme Court that there must be a chain of evidence where no reasonable ground is left for a conclusion which is relevant with the innocence of the accused, and it must so as to so that it is with all human possibility that the act must have been done by the accused. The counsel would like to draw your lordship's attention to the fact there was no eyewitness to the crime, as claimed by my friends and the prosecution that PW2 Komal Singh was an eyewitness to the crime. The counsel would like to state that the statements of PW2 cannot be relied upon, as PW2 suffers from a mental illness named schizophrenia, due to which she could have been easily manipulated by anyone. The counsel would like to draw your lordship's attention to the statements of PW4 Pooja, a resident of Indira Nagar Mohalla, which states that she had seen accused 1 Surekha Singh and accused 2 Mohan Prakash in the bazaar many times, and also the statement of PW6 Sultan, a local grocery shop owner, who states that he had also seen accused 1 and accused 2 in the bazaar many times. Basis the above statements, the counsel would like to submit that your lordship, the above statements do not indicate the presence of any illicit relationship shared by the accused. Merely on the basis of being spotted together in a bazaar, it is incorrect to state that the accused shared an illicit relationship. Thus, until a complete chain of circumstantial evidence is established and it is proved that the accused are guilty, the accused cannot be convicted. The counsel would also like to state that the prosecution has been unable to form a proper chain of events. The counsel would now like to proceed to issue number 1.4, page 19, with your lordship's permission.
Please.
Much obliged. The counsel would like to submit in negative that the accused are not guilty under section 201 of the Indian Penal Code. The counsel would like to state that section 201 of the Indian Penal Code states causing disappearance of the evidence of the offense committed or giving false information to screen the offender is a punishable offense. The counsel would like to draw your lordship's attention to the fact that the court order would subsist for a period of 8 to 10 days, which means that the odor out of the body of the victim would subsist in the area for 8 to 10 days. Had the body of the victim been buried below the bed of accused 1, wouldn't that odor be evident to all the neighbors of the victim who were normal residents, or wouldn't that odor disturb the life of the accused 1 and as well as PW2, the witness? Thus, the counsel would like to state that the body of the victim was not buried under the bed on the 9th of November, and it thus shall have been buried after the same date. The counsel would thus like to explain the other issues through cross-examination.
Please.
The counsel seeks permission to cross-examine few witnesses.
You may.
Much obliged. The counsel would like to first call upon accused number 1, Surekha Singh.
Surekha Singh is not on the witness list, sir. There are only 7 witnesses on the witness list.
The lordship, the counsel would like to examine her because her statements are very important for proving the not proving the guilt of her in the present case.
Find her statement under the memorial itself. No need to verify by the oral conviction.
All right, Your Lordship. The counsel would like to call upon investigating officer Jayant Pawar.
Please.
Hello, am I audible?
Yes, you are audible. Sir, for the record of the court, could you please mention your full name
Jayant Pawar,
and your designation?
Inspector of Police.
The council would like to ask you that since how many years are you in this field?
18 years.
Can you repeat?
18, 1-8.
18 years. Can you explain where was the crime scene?
Crime scene was the victim, the deceased home, which is Indrani Nagar Mohalla number 32.
Okay. Can you enlist the things which you recovered from the crime scene?
3 goonie bags with bloodstain on it, a butcher knife, a box of tiles, used tiles, construction tools, and a goonie of cement.
The next question to you is, you found various things like gunny bags, butcher knife, cement bag, tile box, etc. As you mentioned rightly, that there were bloodstain on the gunny bags as well. And also, according to the charge sheet filed by you, there is mentioned that the butcher knife also contained bloodstain of 8 inches. Did you send this to the forensic department?
Yes.
The council would like to ask, what was concluded in the forensic report?
Sorry, can you repeat?
The council would like to simplify the question for you. What was held in the forensic report which you had sent for the gunny bags, butcher knife?
That is not under my statement.
Okay. Your Lordship, the council would like to make this point to be noted that in 18 years of career, it is a gross negligence on the part of the investigating officer not to collect the forensic reports by the medical professional, which can be very vital for proving the innocence of the accused. In the present case, as investigating officer Jayanpar rightly mentioned that he had sent the gunny bags and the butcher knife for forensic report, and he received the same as well. But there is no mention of the forensic report as to whose fingerprint it was there, and the blood stain which contained was matching with the blood of accused. Number one, blood stain matched with the blood of the victim. No further questions.
Yeah.
The council would like to call upon council number 2 for the further cross questioning.
With your Lordship's permission, the council would like to call upon the investigating officer to cross-examine.
You may.
Much obliged. Hello, sir. I would like to know about the date on which the missing report was filed on Rampal Singh and who filed the missing report.
The missing report was filed on 22nd of November by Arjun Singh.
Could you
Sorry,
repeat the name?
Arun Singh.
Yeah. Thank you, sir. Further, the next question is the date on which the FIR was filed and by whom was the FIR filed?
Sorry, could you repeat?
By whom was the FIR filed and when was it filed?
The FIR was filed by Arun Singh on 24th of November.
Okay, sure. So the FIR contains the name of 2 informants. Would you like to brief me about the presence of their names on the FIR and their roles in relation to this case?
Yes, the informant number 2 is Anmol Chaudhary and informant number 3 is Vinay Mishra.
Oh, so if you could also brief me about the roles of the 2 informants in relation to this case?
They were the neighbors of the deceased.
They were the neighbors of the deceased, correct. So also, if any action was taken on the missing report filed by Arun Singh, the brother of the deceased?
Yes, there was an investigation held where we had sent a team, a petroleum team, to inquire about.
Noted. So one thing, while the victim went missing, I think in today's world, all of us are very much aware, cell phone plays a very important role. And what we know from the investigation conducted is that there was no mention of the phone, of the mobile phone of the victim. We would like to know, was the mobile phone of the victim not traced while the missing report was filed? And also, why is there no mention of the mobile phone of the victim in the reports filed by you ahead as well?
Could you repeat the question?
Sure, sir. I'll simplify the question for you. So when the missing report was filed by the brother of the deceased, Mr. Arun Singh, why was the mobile phone of the victim not traced?
It was not missing. It was switched off. It was out of network.
So but what I understand is the same can as well be traced. And also when the death of the victim occurred, the mobile phone of the victim was not found in the crime spot, or neither was there any mention about it in the reports filed by the investigating officer.
Because it was not traceable.
Noted. Also, sir, one last question. Were you aware about Komal's disease, the schizophrenia part, which she suffered?
No.
Thank you, sir. That's it. The council would like to highlight, on basis of the investigation done by the investigating officer, that there was lack of investigation and also there was miscarriage of justice. Some basic stuffs like, the investigating officer not knowing about the disease which is suffered by PW2, which the prosecution claims to be the sole eyewitness of the crime committed, as well as no trace of the mobile phone. In today's world, all of us understand how mobile phones are much important to our lives, and thus the mobile phone should have been traced either at the crime spot, either in the complete manner or in a broken manner, but the mobile phone should have been found, which again proves the fact that the victim was not murdered in the house, whereas he was murdered outside the house, and then later his body was cremated in the house of the accused. Moving ahead, the council would like to seek the permission of your lordship to cross-examine Arun, the brother of the victim.
Please close.
Much obliged.
Yes, ma'am. Hello.
Am I audible, sir?
Yeah.
So first of all, I would like you to say your name, your age, and your occupation.
Hi, Arun Singh, age 25 years, and my occupation is I'm a salesman in Panchayat present.
Note. So if you could just brief up about your relationship with your brother, the victim, Rampal Singh.
Yeah, we were very familiar and we were very attached. And also, we used to have a conversation on a daily basis because of I used to admire him as my father because he was my elder brother.
Noted. So just one more question. Do you know about any identification mark on your brother, the victim?
Sorry, I'm not aware about that. Sorry, I'm not aware about that.
Noted. When was the last time did you speak to your brother, Rampal Singh?
The last day was on 8th November.
Note. When did you come to Mumbai city?
I came to Mumbai city on 19th November.
Note. So if you could just brief up about the reason why you visited Mumbai city?
Actually, as I said that I was unable to contact my brother from 8th November. So we were very conscious that what's going on over there. So just to find out what's going wrong over there, so I approached Mumbai to identify the truth.
Note. When you reached your brother's house on the 19th of November, did you find something fishy in his house?
Yeah, when I met with Sureka, my sister-in-law, when I asked her that where is Arun, where he has kept his phone. So in a very afraid and scared manner, she said that he has gone to Surat for a merchandise deal. But I have determined that due to her facial expression, she was very scared.
No. So other than that, was there anything else which is fishy in the house, the surrounding?
Not more than that.
Note, thank you. Sir, you arrived on Mumbai on the 19th of November, whereas you approached the police station and filed a missing report on the 22nd of November. We would like to know that what was done in those 2 days. Like, why did it take you 2 days in case your brother was missing to file a missing report with the police?
Yeah, of course. After I met Surekha, when she told me that he has gone for Surat, and he often go for a trip for more than one month. So I keep a patience for 2 days just to see that he will contact us and he gonna call us. But after that, I started the inquiry about my brother, and I filed a missing complaint on 22 November.
Time up.
With your lordship's permission, the council would just like to ask 2 more questions.
It's almost done.
So, with your lordship's permission, I would humbly like to recite the prayers.
Proceed.
Where, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court acquit the accused from the edge offense under section 302, 34, 324, and 201 of the Indian Penal Code. Discharge the accused on insufficient ground in concurrence with section 227 of Criminal Procedure Code and pass any order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good science, all of which is humbly prayed. The defense rests its case.
Any rebuttal?
Yes, Your Lordship. With your permission, the prosecution seeks permission to go ahead with the rebuttal.
Please proceed.
Much obliged. My learned friend's argument had been all based upon intention, knowledge, circumstantial evidences. But my learned friend has failed to explain any of the part with the circumstances of this current case. At no point has my learned friend failed to talk about how the intention was not there between them. At no point has he defended about the fact that there was illicit relationship between the both of them. Another fact, my learned friend's argument has all been upon just one defense, that the statement of PW2, that is Komal, is not admissible as she is of unsound mind. However, we would like to mention certain facts that, first of all, the mental state of Komal has not been in that regard. She is suffering from the first stage of schizophrenia, and as per the medical reports, in the first stage of schizophrenia, the patient does not suffer hallucinations or any such. They just face some behavioral change and some anxiety. That's what it is. Second, my learned friends mentioned that she took sleeping pills before after finishing her dinner. However, as per the statement of Kashinath, which was done during the chief examination, Kashinath clearly mentioned that the prescription was for Surekha and not for Komal. And it is also to be noted that as per all the various medical experts, the sleeping pills, which is of zolpidem tartrate, is not allowed for minors because it is very harmful and dangerous for them. So my learned friend's argument about the same is not admissible. The council would also like to mention about section 118 of the Evidence Act, where it is mentioned that if any child witness is being put on the stand and the evidence which is being mentioned is corroborated with the deposition of the same child witness, then it can be relied upon. Here, Komal has clearly pointed that the dead body of her father was beneath the bed, and same was being found when the investigation was carried out. Another point that the prosecution would like to mention is that, according to my learned friend, if the accused number 1 and 2 are not the culprits, then are they suggesting that whoever the culprit was knew very well that Surekha would buy the butcher's knife, and that there would be sleeping pills at her house, and that there is a convenient hiding place beneath the bed of their bedroom where they can dig a hole of 3 by 4 and hide all the evidences. Another instance to consider is that the flooring of tiles, the digging of a hole, the using of cement, and doing a perfect flooring, this cannot be done by any amateur. It requires professionalism, and hence this cannot be proved that this was not done by accused number 1, that is Mohan. Is my learned friend suggesting that they specifically hired a civil engineer for putting the blame on accused number 1 and accused number 2? The further facts of this rebuttal will be stated by my co-counsel.
Your Honor, the counsel seeks permission to place the further statements for the rebuttal.
Please.
Your Honor, my learned friends have stated that the prosecution was not able to prove beyond reasonable doubt that all the conditions for section 201 were not satisfied. Your Honor, it is humbly put before the Honorable Court that all the evidences were found, the body was found, the butcher's knife was found, the construction tools, the broken tiles, the tile boxes, the bag of cement, etc. were found. Also, the statement given by the witness number 2 clearly states where the body was, and the investigating officer found the body from the very same place. Coming to the next point is whether the intention or guilty mind. The accused has lied about the whereabouts of the victim continuously. They have also lied about the status of their phone. They also have, yes, Your Honor, they also had an illicit relationship. There can be no clear intention better than an illicit relationship to eliminate the one barrier that lied in their way. The body was also found in the house of the accused herself. If the accused implies that it was put over there by someone else, how is it possible that the accused did not notice that something was going on in the house? Lastly, my learned friend also stated that the witness number 2 is very young and she could not understand. However, when the counsel stated, did she know the meaning of the oath? She said no. When counsel explained to her that she could not lie, she easily said, yes, I understand what the meaning of oath is and I will not lie. Similarly, as my co-counsel stated that zolpidem tartar is contraband in India, it cannot be given to children below the age of 18 years. Also, the medicine was prescribed for Surekha herself. The question that arises is Your Honor, just one last statement. The question that arises is how were traces, heavy doses of zolpidem tartar found in the victim's body? 6 tablets were missing from the strip, only 4 were there. And the normal dose of zolpidem tartar is only 10 mg per day. Therefore, Your Honor, the counsel humbly submits that the accused are guilty of all the charges as levied on them as per the first information report. Much obliged, Your Honors.
Anything rebuttal from defense?
Yes, Your Lordship.
Only one.
Lordship, the counsel would like to state that, as stated by my learned friend, that the whole case, the theory of the whole case relies on the facts that PW2 witness could be considered as an eyewitness to this case. But the counsel would like to state that according to the facts stated by WHO, the World Health Organization, sleeping pills are to be administered to the people who suffer from schizophrenia, as the early stages symptoms of them are sleeplessness, which is insomnia. Second, they can also deal around with hallucination, wherein they can be manipulated, they can be dreaming. So basis by what World Health Organization has to say, the counsel would like to state that here witness PW2 cannot be considered as the sole eyewitness of the crime.
Okay. Noted. Yes. Madam.
Thank you, VTM 03 and VTM 04. Your results shall be declared by 3 p.m.